An exasperating fact of life for social scientists is that they regularly discover new and powerful things about better social systems that are then routinely ignored, if not actively rejected, by the policymakers that control those systems. While in the natural sciences, the problem is often that a discovery hasn't yet been made. In the social sciences, discoveries can be made, and yet policymakers nonetheless stick with the bad structure that we have. The reasons are sometimes ideology or policy malice, but just as often the reasons we are stuck with suboptimal social policy is that well-intentioned social actors continue to work within the narrow limits of social or legal concepts that only sustained theoretical reflection can help overcome. This difficult theory work is precisely what Dr. Beverley Clough has done in the book that we're going to be discussing this afternoon, the spaces of mental capacity law moving beyond binaries. Since the Mental Capacity Act, or MCA, came into effect in 2007, Britain has used its statutory principles and the conceptual framework underlying these to make decisions on behalf of persons deemed to lack capacity. The principles were hard fought and appear on their surface to reflect a liberal humanitarian advance that corresponds to the most reformed thinking internationally, codified specifically in the UN's Convention for the Rights of Persons with Disabilities. The UK Mental Capacity Act rests on 5 principles. 1, a presumption of capacity. 2, a need to take all practicable steps to help someone make a decision. 3, not equating an unwise decision with a lack of capacity to decide. 4, acting always in the incapacitous person's, as it's put, best interests. And 5, working towards the least restrictive alternative. And yet, however improved these principles are over their predecessors, they still justify interventions that are routinely intrusive and at times degrading to their supposed beneficiaries. For example, Bev notes in her book that the Act tries to reduce the scope of the category of incapacity to reduce intervention. However, as she puts it, this does not explain why purportedly paternalistic interventions are the only responses conceivable. In other words, even liberalized mental capacity law continues to inflict oppressive interventions on its subjects. Now, this is where Bev Clough's theory work enters to show that the problem lies much deeper than we would normally think. It lies not with this or that application of the Act, or with this or that section of the Act, but with the conceptual framework that constitutes the Act itself. This framework rests on binary oppositions between capacity and incapacity, care and disability, state and individual, and much of the book is devoted to developing spatial and relational alternatives to this framework, alternatives showing both the instability of these boundaries and the way that care might look if we operated without them. Bev demonstrates the need to bring multiple factors to bear on any one case and to see it across time rather than as an isolated point or moment of decision. One name that Bev uses for the alternative to liberal interventions of the mental capacity framework is an assemblage account. And such an assemblage account sees the person not so much in the context of capacity or lack thereof, as in the context of the biology of that particular body, existent communication technologies, available and withheld funding, institutional capacities and their gaps, legislative constructions of relevant technologies, and social discourse constructions of the particular capacity in question. Bev's purpose, as I read the book, is not simply to complicate the questions asked in a particular case so as to head off unjust intrusion in that case, but to redefine the very terrain of state and society to bring the repressed or unseen into proper legal view. To revise slightly one of her citations, everything must be up for reanalysis. Quote, and the scholarly imagination must be attentive to new types of objects not seen, or perhaps sometimes seen and marginalized at the level of state law. That's from Bev, who is citing Margaret Davies. This uncomfortable process of putting everything up for grabs is in fact where the most important advances come from. And in this, Bev Clough exemplifies the search for new ways of thinking that motivates the work that we do here at the Independent Social Research Foundation. Now, Bev's book is the 6th in the ISRF's 2nd season of book launches. We've recently published an ISRF bulletin on a theme that emerges in her book and that had been found in many others of the book launches that we've done last year. And that theme is post-individualism, which would be a system in which social relations and individuals mutually support rather than threaten or damage each other. One of those books was authored by tonight's second commentator, Dr. Ochie Onaze, whose important book, An African Path to Disability Justice, redefines disability justice through his engagement with African philosophy, and specifically his revised version of the concept of Ubuntu. This leads him to a relational, not individualist notion of personhood, one that also does not require, in Ochie's reading, symmetrical capabilities between persons. Other books launched this year include Ilan Ruhl-Wall's book on the role of affects in constituting political movements, Mike Mackin-Wade's book on how community interventions dealt with white supremacist individualism in Burnley, England, Alexander Stingel's work on how collective engagement with digitality might reduce rather than feed precarized labor in the academic world in particular. Jonathan Saha's book, Colonizing Animals, on how the colonial project decimated non-human creatures while also depending on them. And finally, Julia Late's The Disappearance of Lydia Harvey, which is on a young New Zealand woman who was sex trafficked to London in the early 1900s, and the combination of personal agency and support structures that produced a surprising ending to her individual story. Continuing the theme of justice in the care society, next month the ISRF is going to be launching Eleanor Jopp's book, Care Crisis and Activism, which has only just been published. That's a launch that's going to be taking place in London in person, and everybody is very welcome to attend that. But it's also going to be recorded and shared online afterwards if London is a bit too far afield for you. The ISRF is extremely grateful to this collective body of authors and to their respondents for their work and thought and generosity. And thanks this evening go to you, Bev, and to you, Ochie and Ruth, for contributing to what seems to be a growing intellectual movement. So our schedule this afternoon is going to be as follows. We're first going to hear from Bev for about 10 or 15 minutes, talking us through her book. And then we're going to hear from our two commentators. First, we're going to go listen to Ruth Fletcher and then Ochie Onaze, each for about 5 to 7 minutes. Then Bev can respond to them. And after that, we're going to open the floor to questions. Unfortunately, Ruth is going to have to leave us around 6 p.m, but the rest of the panel is going to stay on until about 6:15 or maybe 6:30 British time, as Stuart has already said. So many thanks to all of you for being here to work on this important topic. I'm going to introduce each of our three speakers as we go. So I'm going to start with Bev. Beverley Clough is Associate Professor in Law and Social Justice in the School of Law at the University of Leeds. She completed her PhD in bioethics and medical jurisprudence at the University of Manchester and has been at Leeds since 2015. There she works on issues that she has synthesized in her book very nicely, which include critical disability studies, new materialisms, relationality, spatial justice, medical law and ethics, care theory, vulnerability theory, and feminist legal theory. Some of the articles that she's written include What About Us? A Case for Legal Recognition of Interdependence in Informal Care Relationships, Disabled Justice, Access to Justice and the UN Convention on the Rights of Persons with Disabilities, People Like That, Realizing the Social Model in Mental Capacity Jurisprudence, and Never Too Old for Health and Human Rights. With Jonathan Herring, she has also edited a book that also came out in 2021, which is called Disability Care and Family Law, and it was published by Routledge. Bev, it's really great to have you on this afternoon. Over to you.
Thanks very much, Lars. So yeah, first, some thank yous from me. Huge thanks to the ISRF. They've been a really fantastic funder, doing really rich and exciting work. And they've been really good to work with throughout the fellowship and after the fellowship, and particularly in preparation for today. So thank you, Lars, Stuart and Chris. Also, massive thanks to Ruth and Ochie for agreeing to be involved today. You know, for just, I know it takes quite a lot of time to do these things and to engage deeply with the book. So thank you for that. And I'm actually really looking forward to hearing your reflections. So I thought I would start with thinking about a case and a kind of case that's been bothering me for a while. So thinking about this case that involved a 34-year-old man with autism, significant learning disabilities, physical and sensory impairments, who's residing in a wholly unsuitable flat, and most people are in agreement that it is wholly unsuitable. He can't stand independently, so he uses a wheelchair, and he requires one-to-one and sometimes two-to-one support. His flat essentially is too small to accommodate his wheelchair, so he often has to pull himself along the floor, which has resulted in painful bursitis of his knees and calluses on his knees and ankles. The flat has got no outside space. Now he's been placed in this accommodation as part of a care package that's been funded by his clinical commissioning group and the county council. So this case came to be viewed through this lens of mental capacity. So Lars gave a kind of brief overview of mental capacity law at the outset. So I'll just kind of gloss over it here, I guess. But essentially, mental capacity laws are legal frameworks that govern the circumstances in which a person's decision-making can be interfered with by others. So in English law, which is the focus of this book, we've got the Mental Capacity Act 2005. And essentially, this enables decisions to be made in a person's best interest if they're deemed to lack mental capacity. And this lack of mental capacity is on the basis that they lack some kind of functional cognitive ability, and that this has been caused by a mental disorder or cognitive impairment. So situations like learning disabilities, dementia, people who are in a coma, for example. So thinking back to this case of the man in the wholly unsuitable accommodation, as I said, this came to be viewed through the Mental Capacity Act. The legal response to this through this framework was to state that he lacked mental capacity to make decisions about his residence and care. There was a recognition that whilst this amounted to a deprivation of his liberty, it could be justified as being in his best interests. So in being deemed to lack mental capacity in relation to his residence decisions, this effectively placed the power to make decisions about where he lives in the hands of social care professionals and in turn through the Mental Capacity Act to the judiciary. Arguments that more appropriate accommodation ought to be found for him were dismissed through the court protection because they distanced themselves from what's seen as public law decision-making processes. As such, they were purportedly bound to endorse the situation as being in his best interests. They deemed themselves to have no power to force local authorities to produce alternative options here. So there are a number of angles, from which this case could be critiqued, and I do so in the book on a number of occasions. As I said, it's a case that often still irritates me, and I often come back to it in my thinking because to me it reveals so much. So for now, it serves as an important illustration of the range of issues that the mental capacity legal framework engages. And the resonance of these with broader debates across law, the humanities and the social sciences. It invites us to reflect on the removal of legal agency through a legal framework distinguishing disabled and non-disabled individuals on the basis of rationality, a framework which is ostensibly built on Enlightenment ideals of autonomy and empowerment. In doing so, questions as to legal subjectivity and long-standing critiques of the liberal legal subject are engaged. It calls into question the role of the state and institutions in the shaping of individual choice and the divide between the public and the private realms, which has served to exclude problems from legal and political gaze and to distance the state from responsibility. In this case, we see that the man has been placed in this wholly unsuitable setting by the state, but the response of the courts is to privatise responsibility for it. In fact, to abdicate any public responsibility to find better alternatives by stating that this is in his best interests. To me, it's a clear example of a number of dichotomies of powerlessness working together. Care and the role and place of care in our society becomes a really tangible and urgent concern to me through this case. Feminist legal theorists, social policy scholars, care ethicists, geographers, they've all been grappling with care as this kind of practical and lived experience. And here in this case, with the laying bare of a legal, social and political framework which can create and endorse such uncaring conditions, liberty and the justifications for the deprivation of liberty through this legal framework are similarly called into question here testing the boundaries of theoretical debates as to what is meant by liberty and the role of the state and individuals within these debates. So turning to the book more broadly then, what is the book about? Essentially, it's an exploration of the conceptual, legal and institutional spaces that mental capacity laws inhabit, and really wanting to think more deeply about what the ideas underpinning these tell us about how law understands and constructs disability and ability, and how these ideas shape the way that we can respond to and conceptualise issues. So in terms of what drove me really to write the book, my PhD research was focused really on relational approaches to mental capacity law. I was very much kind of embedded in the relational autonomy literature. And I was really interested in what these could do in terms of exposing what was missing in mainstream mental capacity and bioethics scholarship that to me took a broadly kind of liberal legal view. So when I was writing the PhD, a number of things became quite clear to me. One is that this relational autonomy literature often became constrained by the same logics and binaries that it was trying to critique, and the same logics and binaries that shaped a lot of the liberal legal accounts. So autonomy as a concept has attracted and still attracts a number of critiques from relational perspectives. But I found that when thinking through what this meant in terms of law and policy, it tended to hit up against this idea of paternalism and this kind of the binary framing of autonomy and paternalism here. And I felt that the boundaries of this debate were essentially being led by liberal legalism and the liberal logics that we were trying to escape from. Another thing that really struck me from doing my PhD research was that disability is curiously quite absent in mental capacity scholarship. So what I mean is that it's there, obviously. You know, the existence of disability is pretty core to the Mental Capacity Act, but it's there in a very problematic way. And as I became more engaged in disability scholarship, particularly as a member of the Centre for Disability Studies at the University of Leeds, it became clear that the under-theorising or misunderstanding or perhaps deliberate framing of disability in the mental capacity legal frameworks plays a really important role in how it works. Thirdly, the book was driven by the existence and increasing debate about an international convention, the UNCRPD, the Convention on the Rights of Persons with Disabilities. This essentially has been seen as quite a potentially transformative convention for disability rights and justice. It offers really potent challenges to the Mental Capacity Act and legislative frameworks that essentially deny people's legal agency on the basis of disability. But what I'd seen in the debates was that these ended up being kind of viewed through the same lens as existing debates. So it was all about autonomy or paternalism, disability versus non-disability. So it felt like we were treading the same ground there. So I guess I was kind of frustrated with some of the limitations of the kind of conceptual and pragmatic concerns about the legal frameworks. And I sought to consider some of the ways that engaging with disability studies and some of the more dynamic relation and spatial approaches could offer conceptual tools to kind of get us outside of these constraints and to open things up a little bit. So what did I find in doing this? I guess one of the big things, and what really drove the structure of the book and the structure of my thinking, was that the binary framing of liberal legal approaches tends to draw the boundaries of conceptual and legal responses. And in doing so, they really constrain legal, professional and institutional responses and representations of what has occurred. And in doing so, they've got really important material and discursive effects. One of the things that's quite important is what's left outside of the binary framework, which then becomes obscured, and it prevents accountability and responsibility and the potential for structural and institutional change. And I think this is really important for things like the CRPD. If we need to be attentive, I guess, to these structural and institutional problems. And at the moment, we're constrained from doing so if we're having to think about things through the problematic framework. So what are some of these binaries then? Lars mentioned some in the introduction. We've got things like capacity, incapacity, autonomy, paternalism, empowerment, protection, care, disability, disabled, non-disabled, public, private, and freedom and deprivation of liberty. As I said, these seem to me to work to create insides and outsides, to draw lines of accountability, and to shape norms and create others. In the book, I discuss how they're mutually intertwined and dependent upon each other. They help to sustain each other. And for me, this offers quite an important insight for people who want to imagine different progressive frameworks. I think we need to be really attentive to the way that these binaries work and how they sustain each other, how they've been created, and the processes that maintain and reinforce them. Because this signals sites, really, sites that we can focus on dismantling them and beginning to unravel them, and hopefully to open up different ways of responding. So I think I'll leave it there, and yeah, allow the panelists to offer their reflections.
So we're moving on to Ruth Fletcher now. Ruth Fletcher is Senior Lecturer in Medical Law at Queen Mary University of London, where she teaches on medical law, medical ethics, legal theory, and feminist thought and praxis. She was previously the Editor-in-Chief of Feminist Legal Studies, and she was recently awarded a Leverhulme Research Fellowship to work on legal time and reproductive justice, which she's going to be doing in the academic year of 2022-23. Ruth's research brings together critical legal studies, feminist theory, and medical humanities. And in 2017, she co-edited a very interesting volume on the theme of care, which is entitled Revaluing Care in Theory, Law, and Policy. One area in which she has made a particularly important contribution is that of reproductive rights and abortion law, a topic she's worked on for over 2 decades now. One of her articles on this subject that I would recommend to everybody present today is called #RepealThe8th, Translating Travesty, Global Conversation, and the Irish Abortion Referendum. This essay addresses the campaign to repeal the 8th Amendment in the Republic of Ireland and decriminalise abortion. I would recommend that everybody read it, not only because the theme of decriminalising abortion has sadly become very timely in recent weeks, but also and especially because the essay conceptualises law as a potential tool in the arsenal of feminist praxis. And that chimes very nicely with the central themes of Bev's book and the themes of this book launch. Ruth, thank you very much for being with us this afternoon. It's a great pleasure to have you with us, and over to you.
Wonderful to be here, and thanks, Bev, so much for writing this book. It's just full of riches, and it was a real pleasure to read, and I know I will be mining it for all sorts of insights in relation to mental capacity law, but also much more broadly, just in relation to thinking in an interdisciplinary way with law as well as against law. So thank you for writing the book. I've really enjoyed it. And I know my students are already enjoying engaging with it too. So it's one of those wonderful resources that works across research and teaching and helps us decompartmentalize in that way, I think, too. So we get beyond boundaries in that sense too. So, so I suppose you've introduced the book beautifully, and I think one of the main richnesses I found in it, from my point of view, was the way that you work so carefully with legal doctrine, the way it takes legal form so seriously through the jurisprudence of the Court of Protection. And so, so being able to, do that sort of deep dive with legal form and legal doctrine, but doing it in a way that enables us to reimagine what law might be, and which, isn't limited by a sort of technical approach to doctrine, obviously. So I love that combination of working the methodology of doctrine, but taking it in a new direction. And so, I'll come back to that perhaps, but that was definitely one of the richnesses about the book, and I think it joins with all sorts of other creative legal projects in that way. Feminist judgments projects, projects which take doctrine seriously as a collection of primary sources for socio-legal inquiry, and take it in new directions. The second key thing second key richness in it for me was the way in which it engages with differently situated beings in our world, right? The way in which you do a wonderful job of both doing a focus on disabled subjects, differently abled subjects, vulnerable subjects, people who are more likely to be scrutinized for not having capacity. And so you bring these lives to academic inquiry in a really situated and nuanced way. And I really appreciated that about the book. And I suppose the fact that it manages to do that in a detailed and serious way, while also showing us that what we learn as we look at lives that are scrutinized, overly scrutinized by the Court of Protection, that we also learn something for all of us, right? So there's that tension between addressing the particularities of everything from impairment to social vulnerability, while at the same time showing us, that we learn about being in the world in this way. So I thought you managed the balance there, not being overly generalist and not being overly particularist really well. And then the third sort of richness I wanted to focus on, it was in relation then to the way in which you take spatiality, in particular legal geography and relational theory, the way you bring those tools, those intellectual theoretical tools, to the study of mental capacity law. And you have definitely, just cracked open the field in the way in which you've shown us how mental capacity law now can learn so much about thinking about landscapes of care and about thinking about spatiality and relationality. So bringing that kind of thinking, those tools to mental capacity law was just wonderful to see, and vice versa, right? Thinking about how we can look to mental capacity law and to judgments, but also all the kind of expertises that are involved in the jurisprudence, social work expertise, familial expertise, experiential expertise, that make it into law, right? And so there's such a rich body of knowledge there then opened up for geographers, for relational theorists. And so that was beautiful, the way you managed to show us the relationship between spatiality and the jurisprudence of the Court of Protection. And so those were three kind of key contributions over and above, I guess, the particular study of mental capacity law. And it left me then with wondering how I might visualize, I guess, the assemblage or the apparatus that you trace for us as you move beyond boundaries then, right? So such a key part of your contribution is showing us how this binary of capacity and incapacity, that the courts and legal professionals and anybody engaged with the framework gets boxed into the binary, and you show us how that is troubled, how judges struggle with that as legal actors and come up against it, and so ways in which those binaries then map on or consolidated by other binaries, as you said, in relation to care and disability, and in relation to powerlessness, the state and the individual. So, you very much operationalize, I guess, intellectually what an assemblage looks like, how it takes us beyond the 1-0 or the binary, or the cut, right? So the image of the cut that decides you're either capacitated or you're not. So, but then I was trying to think, okay, well, what does this assemblage look like? Maybe, how can we think about, how would I visualize, I guess, a kind of the assemblage of capacity assessment that you're mapping out for us, right? I think that you have made a contribution over and beyond the critique of the binaries. You've shown us how assemblage works, but I suppose I'm leaving the book wanting to think more about how we take this multidimensional infrastructure and apparatus forward. And so far, the image I'm coming up with is an image of a sponge, right? So sponge as something, because something that is fluctuating, right? So how do we take the feature of capacity, the fluctuating capacity that shows us the limits of the binary, and how do we turn that into something material that helps us understand how assemblage of capacity works then? And so, you know, the sponge is something that can be pushed in and out, can be fluctuating that way. It's got holes, people slip through it, but it might also, you know, be resistant and hold people together. It can be caring, but it can also be depleting. And so that was a question I had, I guess, coming away from the book. How do we then work with a concept of apparatus in a multidimensional way? And that's as far as I've got so far. The other key thing, I guess, was I think it opens up for us in really interesting ways. You've given us a touchstone now that we can use to have conversations with older materialist literatures, right? So thinking about the social reproduction literature and thinking about the way that care labor gets depleted and needs to be replenished. So I'm thinking about the work of Shirin Rai. I'm thinking about the work of Veronica Geico and Argentinian feminists contributing very much to the revitalization of social reproduction and Marxist materialist feminism in that way. So I would love to pick up that conversation with you at some point. And then I'm also thinking about a connection, a future connection as well for me, with abolitionist feminism and wanting to move beyond the harmer binary and thinking about how care and harm, so there are sources there definitely, I think, in terms that you have enabled a connection with. And so I look forward to making those connections with your work and my own work and with other people, hopefully. So thanks very much for the book.
Thank you, Ruth. That was great and very helpful and very generous. Okay, moving on to our third speaker, Oche Onazi. Oche took law degrees from the University of Jos in Nigeria and of Warwick, and he holds a PhD from the University of Edinburgh. He has taught at Dundee and Southampton and is currently senior lecturer in law at the University of Northumbria. He's also a qualified but non-practicing barrister and solicitor of the Supreme Court of Nigeria. Oche's research covers two related themes. First, it covers the theoretical study of law from Southern perspectives and the critical approaches of other disciplines, such as sociology, politics, history, and philosophy. The second strand covers the role of law in development, especially the relationship between human rights and development, community approaches to development, and the relationship between these themes and the philosophical perspectives of the Global South. I've already mentioned his most recent book, An African Path to Disability Justice, which everyone here should go and read. But he is also the author of Human Rights from Community, a rights-based approach to development, which appeared in 2013 from the University of Edinburgh Press, if I'm remembering that correctly. Oche, it's a great privilege to have you on another ISRF book launch, and the floor is yours.
I'd like to start off by saying a big congratulations to you, Bev, for a rich, wonderful, and very thought-provoking book. It's been a pleasure to read. I've definitely learned a lot from reading it, especially having not engaged with mental capacity law in the past. And one of the things I picked up was this alternative that you present of how a theory and practice of mental capacity law can be reimagined by paying attention to material structures that mirror or shape social relations. I think readers would find a very compelling argument that the Mental Capacity Act is both underpinned, but also undermined by Enlightenment ideals, which have made mental capacity law discourse revolve around the kind of static binaries that you introduced in your brief overview of the book. And so you tell us that to overcome this sort of binary discourse, we need to be attentive to a sort of fluid, complex, and relational discourse, one that is characterized by complex interpersonal and institutional relations. And so one of the things I sort of picked up from reading the book, and a feature that I was quite attractive to, is that of relationality, something that you do not just from legal geography, but from, to a certain extent, from the feminist or relational feminist literature. And like you, I think relationality is a promising way of understanding the human condition, as well as thinking about disability and disability justice. Perhaps the main difference between your work and mine is that I focus mainly on African philosophy to show how disability justice can mirror a relational community ideal. It may interest you to note that African philosophy does avoid the kind of binary thinking that you are critical of in your book, and that's because African philosophy is fundamentally non-dichotomous or non-Cartesian. It conceives of relationships and complex interactions, such as between the mind and body, the unborn, living, and the dead, the spiritual and material world, relationships between immanence and transcendence, and of course between individuals and community. So like Ruth, I do agree that this is a very important book, and you importantly and more specifically have contributed to how relationality can be understood in the field of disability studies through the kind of spatial analysis that you offer. And so, like I said from the outset, I do have a lot to learn. It's a book that I'm certain to come back to and study more carefully because of its richness and complexity. And so I hope you would excuse me in asking a few questions, and that is really because of the richness of your argument, that there's some things that I can't say that I have completely understood, and I do have a lot of questions to ask, and perhaps we'll carry on with that conversation elsewhere. But for purposes of the conversation today, I would try to limit myself to two sort of brief issues. One of the interesting aspects of your argument that I found is the centrality you give to dependency, which in part is influenced by the literature on relational feminism. It's also a literature that I've engaged with, and I find some of the insights quite attractive. And therefore, I was pleased to find an analysis of Eva Kite's work in your book. However, I'm not sure I properly understood why you found her work static and linear, especially in thinking about care and disability. I could be wrong, but I think quite differently of her work. And first of all, and I think something that has already come up in the presentation so far, is that her work stands out as she's one of the few philosophers that actually takes up the challenge in engaging with cognitive or mental impairments. And this is something that is not sufficiently or satisfactorily done either in philosophy or by advocates of the social model of disabilities. And more specifically on the question of disability and care, I do think that Kitte's work does recognize the kind of continuities between disability or the disabled and the not so disabled, or between normality and so-called abnormality, as well as between care or caring and being cared for. And this is particularly because she sees the ability to give and receive care as a source of human dignity, which is not different from the capacity, or not inferior to the capacity for reason. And this is why I think for her dependency is important, and why she calls for a radical reform of Western political philosophy or theory to make dependency its defining feature. So she tells us that an important way of achieving this is understanding how people move in and out of dependency. And this helps us appreciate disability as part of the species norm, a moment in each of our lives, and a possibility that is inherent in being human. She calls us to embrace the inevitable dependency of certain forms of disability, which should be placed in the context of diverse dependencies. As Kitte herself puts it, when we recognize that dependency is an aspect of what it is to be the sorts of beings that we are, we as a society can begin to confront our fear and loathing of dependency, and with it of disability, when we acknowledge how dependence on another saves us from isolation and provides the connections to another that makes life worthwhile, we can start the process of embracing needed dependencies. Another aspect of your work that I found attractive is your analysis of the United Nations Convention on the Rights of People with Disability, and which you suggest potentially challenges the liberal logics underpinned by the Mental Capacity Act. And at various points you discuss articles 14, 19 of the convention, but you're obviously more interested in Article 12 on universal legal capacity. And what you try to show us is how it can potentially transform mental capacity law in the UK. And although you acknowledge that the convention may be a product of the same liberal legal ideals that you criticize in your book, you suggest that it may unsettle the traditional boundaries of the domestic liberal legal discourse. And you suggest this for different reasons, partly because of the involvement of disability activists in its drafting, but also the inclusion of positive state obligations. I would like to nudge you or push you a bit on this point, to expand on it a bit more, because I do wonder if it takes the liberal foundations of the Convention and human rights discourse for granted. And perhaps the reason I'm mentioning this is because I'm perhaps more skeptical than you are of overcoming the individualistic foundations of the Convention and human rights discourse, which for me prevent a number of things, especially taking things like dependency and relationships seriously. I would pause here and just to say in summary that thank you for the opportunity to offer these brief comments on this very important book, and once again congratulations for writing such a wonderful and thought-provoking book.
Thank you, Oche. That was very helpful. So before we go on to the Q&A, we're going to go back to Bev, and she can reply to the questions and comments that Ruth and Oche fielded. In the meantime, I would invite the audience to share any questions they have with any of our panelists for today. As Stuart said at the start, you can just click on the Q&A button at the bottom of your screen and just type a question, and we'll get around to that once Bev has had a chance to reply to our two speakers. So Bev, back to you.
Fab, thank you so much to Ruth and Oche. There's a lot for me to kind of think about and reflect on there, which is always good. So yeah, thinking about what Ruth was saying about the assemblage concept and how we can kind of visualize and concretize it. I think what you were saying about the kind of the fluctuating nature of it, to me is kind of the difficulty, but something that I'm wanting to look at next. I think this is probably one of the really interesting aspects of it, in that it's kind of constantly changing and shifting because of the dynamic nature of it. I think one of the things that I've not necessarily touched on too much in the book is that issue of temporality and how that can shift that assemblage, and precisely in that fluctuating in the way that you frame it. So I think there's a lot for me to think through there. It's definitely where my thinking's going. So it's good that that's something that you've picked up on. I think temporality in relation to mental capacity is really interesting, because one of the things when I find myself reading a lot of the case law, I'm always wanting to know what happened before, what came before, what were the relations before, why has this come to the court protection now, and I want to have that additional information. And to me, I think that it kind of touches on what you were talking about, Oche, about Article 12, because I find that a lot of the mental capacity scholarships, quite rightly, I can see focus on Article 12 because it's about that right to legal capacity. Now, the reason that I find some of that scholarship tricky is because it needs to be attentive. It's not just that we will be saying you have or lack capacity at that point. The CRPD will fundamentally shift a lot of kind of state-individual relationship on an ongoing basis. So it's not that the state's suddenly going to get involved at that point of questioning capacity. The focus, to me, on positive obligations in the Convention means that the relationships prior to that point of questioning will be very different. So, support would be different. Support would already have been there before we're even asking that question about supported decision making. So everything becomes kind of shifted. So when I try and concretize it, it does move a lot in my head, precisely the way that Ruth's talking about. So I think that temporality is really important, both in terms of how we critique the Mental Capacity Act and case law, but also in terms of, I think temporality is really important for the UNCRPD. And when we're thinking about, what it would require and what it would mean for questions of capacity, I think we need to also be aware of not just Article 12, but all the other articles, and what impact that would have on that landscape of care and service provision and accountability and responsibility. So, but yeah, that's a really useful question, actually, Ruth, for concretising something that I've been thinking about for a while. Thank you. So yeah, some Archie's reflections. So firstly, yes, the point about your book and the frameworks that you use there, and the importance of relationality to those, and that kind of non-dichotomous thinking. I definitely want to have an opportunity soon, hopefully, to discuss this with you, because I think there's some really important affinities there, and I think, you know, thinking through those together could offer a really important, powerful lens going forward. So yes, definitely would like to speak more on that. Yes, so the centrality of dependency and Eva Kitay's work. I find myself struggling sometimes with Eva Kitay's work, because I really appreciate and definitely do not want to undermine the work that she has done. I think it's hugely important, particularly in a very difficult philosophical space that she entered, and was, you know, one of the first to do so in a really powerful, really compelling way. I think where my discomfort is that it could be utilised by the more kind of liberal frameworks that I'm referring to. It could easily kind of slide into that and be utilised in a way that could result in quite problematic outcomes. One of these is this idea of derivative dependency, and I know that it isn't just Kitay that uses this term. To me, that positions the carer as only dependent as a result of being a carer, so only as a result of caring for a disabled person. And I think that undermines the idea of universal dependency and interdependency. So I think it could inadvertently set up different statuses, which is something I'm trying to avoid. And Laura Back talks about this similar problem with the idea of nested dependencies that Kitay's work has drawn upon, which sees the disabled person's civil and political membership as kind of nested within the carers. And again, that's something that I also struggle with, because it almost becomes hierarchical there. And I think, you know, with the frameworks that I'm engaging with, that hierarchy becomes problematic, because again, the dependency, the interdependency, those kind of mutual relations are seen as universal and kind of just an ontological universal point, rather than something that only occurs as a result of being a carer. And I think, you know, some of the points that you made there are important, because she does, particularly in later work, talk about how those relationships shift. And I think that's something that I also want to foreground in my work. The problem, you know, it becomes very problematic if you try and put people in static kind of status as carer or disabled person. I think I talk about that in one of my chapters, and the mental capacity Act really kind of stumbles over that. And I think Kitay is also keen on that idea of the interchangeable status, but I think that could be you know, undermined a little bit by that idea of nested dependencies and derivative dependencies. So that, you know, it's not that I necessarily disagree with Kitay's kind of body of work and the point of what she's doing. I think it's really powerful, but it's just little kind of concerns that I have that I'd like to move away from. Have we got time to respond to the CRPD point, or do we need to move to questions? Yeah.
Go on.
So with the CRPD, I have a very tricky relationship with the CRPD. So, I mean, on the one hand, it prompted the book, because, you know, as I said at the outset, I was really frustrated with the way that it was almost a kind of foregone conclusion whenever you started to talk about capacity. It was always, we were always kind of falling into the same discussions. I saw the CRPD as a really important tool in some ways to force us to look at things differently. And that, in a way, I'm using it as a kind of heuristic device, I guess, to force us to think about things differently. And I know that a lot of the scholarship sees it as very individualistic and liberal in that idea of, you know, Article 12, and that potentially been interpreted as a right to be left alone. I don't necessarily read it in that way. I tend to try and read the articles through each other, and I feel, and I think the committee have said similar, that they are woven together. And to me, as a whole, when you start to piece it together, I can certainly see important approaches there that aren't necessarily tied to individualism. I think the problem is that there are so many different people invested in the convention, in its framing, that a lot of the potentially more progressive stuff had to go to enable it to get over the line. So it's not necessarily in my work that I am saying this is the right, you know, we've got it, we've got the framework here. It's not, it's, as I said, it's more that it offers a really important opportunity, and through engaging with the articles and what they might mean, I think that could force us to take things forward differently.
Thank you very much, Bev. We're going to move on to the Q&A section now, and I would invite Oche to also be put on the sort of spotlight. I think Ruth is going to have to leave us in a couple of minutes, unfortunately. So Ruth, thank you very much for joining us, and hopefully we can continue these conversations at some other point. As I said before, we're very happy to receive questions from the audience. Who you can put them in the Q&A. As we're waiting for those, I've got a question for you, Bev, which I think also could be directed at Oche and your own work, which is that as I was reading your book, and as I said, I had a similar experience reading your book, Oche, it occurred to me that the kind of critical conceptual work and philosophical work that both of you are calling for and doing almost inevitably encounters a problem of what you might call transformational scale. And by this, I mean the law, particularly British common law and sort of Commonwealth law that derives from it, does not consist of neat, distinct areas, but is a sprawling, expansive tradition with intersecting legal, legislative, and jurisprudential principles and traditions, and you know, that sort of stuff. What that implies is that once you start challenging the philosophical underpinning of one subdomain in that tradition, and in your case, that's mental capacity law, you almost inevitably end up challenging the whole tradition. So it seems to me that the kind of conceptual work that you were doing, and this also applies to the work that Oche and Ruth are doing, could potentially amount to what, in the conclusion, referencing the UN Convention for Rights of Persons with Disabilities, you, Bev, call an existential crisis. So it could cause an existential crisis for the whole legal apparatus, such that if the feminist materialist relational understanding of subjectivity that you're working with were to be taken seriously, it would imply that, you know, we'd need revolutionary change. So my question, I suppose, is to both of you: do you agree with this sentiment? Do you think that this is the level of change that we're looking at? And if so, how do we, as critical theorists, as feminists, as disability activists, face what seems to me to be a hugely challenging task?
Yeah, I think it's kind of a perennial issue, isn't it? I think one of the things that I'm hoping that can be taken from the book is more to be mindful of that broader, the sprawling kind of landscape that you talk about, because all of these binaries that I draw attention to, or the majority of them anyway, are embedded in, you know, numerous legal frameworks. So they're certainly not just issues about mental capacity law. And I think, yes, so there's almost a kind of revolutionary element, if you start to disentangle some of them, then does that mean that we have to kind of do away with all of them? And also new binaries will potentially pop up along the way as we begin to do that, which we need to also be attentive to. I mean, Margaret Davies' work is really great for talking at that much kind of broader level about, you know, Law Unlimited is the name of her book, and that's really interesting for that more kind of transformative, broader level stuff. I think if I tried to think too much about that, I would drive myself mad, you know, given that I'm just trying to focus on mental capacity level at that deeper level. But I think that you also need to be attentive to the broader level stuff, because any attempt to transform anything in mental capacity law is always going to be constrained by those binaries and the broader legal frameworks that it's situated in. So that, you know, to me, that it's more the case that be attentive to it when we are making these arguments for legal change. Be careful what you wish for, think about the unintended consequences of doing so, because you might inadvertently shore up another of the binaries, which could be equally problematic. You know, that's particularly pertinent in relation to what we were saying about Article 12 and that right to legal capacity. That, you know, if you really hammer that route, then that could inadvertently kind of shore up that public-private divide and cut off arguments about state responsibility and accountability, and then it becomes a privatised issue of leave people to it. So I think it's really important to draw attention to that broader landscape, without trying to drive me mad in unpicking it all.
Yeah, that makes sense. Oche, did you have any thoughts in relation to this?
Yeah, this is it's a hugely difficult question, and one thing that I thought of in relation to Bev's last comments is the kind of difficulty that you sort of could witness in the sort of drafting process of the convention itself, being a sort of universal document that had different disability groups thinking about what the convention should be in sort of an agreed way. So you had a lot of disagreements from representatives from the global south about certain provisions. You discussed Article 19 in your book. There were, lots of objections to the emergence of living independently. The African delegation said, you know, Africans don't have a conception of living independently. It doesn't make sense. So it's a hugely difficult question, and perhaps some of the recent developments on the African continent sort of give an indication that the kind of wide consensus that was viewed as to the number of Africans that signed up the convention was sort of a sort of fiction, because they've gone on to draft a protocol, which I don't think is the right way to proceed because of the way they've gone about it. But there's still a lot of disagreement. But more specifically for me in my book, it's hugely difficult, the point you're making, Lars, because I'm trying to work with a sort of indigenous concept that originally was not intended for the modern nation state. And that's sort of the initial objection I get when I talk about Ubuntu or other relational ideas of community. There's some experience in South Africa of its application, but it's hugely difficult how it will work either independently or in combination with more regular legal doctrines. So it's something that I continue to think about, and perhaps the basis of my continuing work to see how you can cross that sort of divide with bringing in not just Africa, but new ideas in a space that is dominated by, if you like, mainstream concepts. It's either, in the one sense, it transformed those concepts into something else, like you were saying with care and dependency. It's not what you would originally have imagined when you formulated those ideas. Yeah.
Thank you, Oche. We've got a very interesting question in the chat, which is from Jonathan Herring, who I believe is your co-editor, Bev. And they ask, well, they say fascinating discussion, and then they ask, this is a foundational question, do you think we need to do away with the very term disability? I'm going to pitch that to both of you.
My view would be no. I think my sense, obviously, disability is a really powerful concept, a really powerful tool for kind of drawing attention to, I guess, that important relational interaction between bodies and society. So I think that it's not necessarily that disability needs to be done away with, but more the kind of the flip side, that the thing that it's positioned in, you know, in contrast to, so non-disability, because I think what my work is trying to do, and the kind of critical disability studies work is trying to do, is to rethink concepts through disability. So what does disability tell us about other concepts and what's wrong with other concepts? And I think it gives us a lot of food for thought about what is wrong with the concept of ability or non-disabled, and the problems that are caused by reinforcing this idea of people being either disabled or non-disabled. I guess it ties with what Ruth was saying about the book, how it forces us not to think about kind of disabled people or vulnerable people as kind of pockets, but about what it says about all of us and our relations to each other in society. So the short answer would be no.
Well, I'm not sure. With my sort of African philosophy hat on, and especially because the way in which African philosophy is generated from different African society, there is no concept of disability in many African societies. So you have different ways of understanding that sort of human condition. A lot maybe negative, but there are a lot of positive conceptions of what it means to experience that condition. So I'm a bit, something I have to think about, but I'm a bit ambivalent about whether it needs to remain as a concept.
I'm interested in what you said, Bev, about maybe getting rid of ability such as it is. What it makes me think of is how there are other terms that in maybe recent decades have been proposed to precisely make visible certain kind of subjectivities or positionalities that tend to be taken as the norm, and precisely by naming them does it become I don't know, a useful concept to think about. So I'm thinking, for example, within disability studies of being neurotypical, or within feminist and queer theory of being cisgendered, which is a naming practice in which seems to me to be an effort to make a certain assumed position precisely nameable, and in so doing maybe taking some of its assumedness or some of its normality or some of its sort of, I don't know, hegemony away. Would you agree with that, or do you think that I'm really talking about something else and it doesn't necessarily apply to the concept of disability?
I probably have to think about it a little bit more, but I think there is that sense in which it is shifting a central kind of norm. You know, shifting from that as being the yardstick to which we have to compare things to. So I guess, you know, with the broader liberal legal subject idea, and that idea that it's built upon that autonomous male white individual, and shifting that and recognizing that doesn't exist, and we need to build laws or policies on the basis of that not being the yardstick. So I can see the kind of the logic there is similar.
Yeah, that makes sense to me as well. We've got another very good question from Justine Bochenek. They say, thank you for this discussion and congratulations on your book, Bev. I wonder if you could expand a bit more on the spatialization concept. Do you have any examples of landscapes of care in which the Mental Capacity Act framework is successfully challenged? And what is it about the nature of spatialization that allowed for this challenging?
It's a tricky one, because I think I probably tend to paint a bleak picture in some ways of the Mental Capacity Act. I think, yeah, looking back sometimes I think, have I been too bleak? Whereas others have said that they can see you know, the scope for hope and change coming through in the book. So I do hope that that comes through. So the spatial, it's not necessarily, I can't really think of any examples where the spatial has been engaged in a kind of progressive way yet. Partly because the space is very much a kind of liberal bounded space. So the critique that I present of much of the case law and how it works in practice is that it's spatialized, but in a very particular way that, you know, that creates these boundaries between people and between individuals and society. So what I'm really seeking to do with the spatial is to show how those individualized bounded spaces have been created through law, kind of over time and through kind of policy decision making, really to suggest that they're not fixed, and that we can draw the lines in different ways and we can draw the boundaries in different ways. So yeah, there hasn't necessarily been an example where that has struck me as a re-spatialization, I guess, you know, in case law so far. So yeah, there is a spatialization there, but it's a problematic one.
Thanks, Bev. We've nearly come to the end of today's book launch, but I just wanted to end with a final question to you, Bev, which is, what's your next project going to be?
One of the things that I've been thinking about comes from the chapter on liberty, and the idea of home that comes through there. So I've been thinking for a couple of years now about how that interaction between liberty and home, because home is a very kind of spatial concept, I guess, and there's huge literatures on home, what home is, how we understand home, how home's created. But I think home and disability is a really interesting interaction, and particularly how the law, through things like the deprivation of liberty safeguards, and through ideas about like the public-private divide, how that constructs ideas of home for disabled people, and what the effects of that are. So yeah, that's something that I've been pondering and certainly want to take forward. And the temporality point, so it's been kind of in the back of my mind, and now that Ruth raises that point about the fluctuating assemblage, I think it's something that I'm going to have to grapple with.
Great, that all sounds brilliant. So we'll very much be looking forward to that. Oche, do you have any parting thoughts for us before we close today's session?
Just to say thank you to Bev for inviting me to comment on your book. I really enjoyed reading it, and congratulations again for that wonderful book, and also look forward to talking to you about things we have in common. Hopefully we can take things forward. Thanks,
Oche.
Thank you.
Okay, I very much agree with all of those sentiments. And thanks everyone for attending and for your very interesting questions in the Q&A. And thanks Bev and Oche very much for joining us. Thanks Ruth as well, who has already had to leave us, for a very interesting discussion, which we hopefully will be able to pick up again soon. And hopefully see you all again shortly for another ISRF book launch.